Oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Please be seated.
Good afternoon. We're pleased to be here this afternoon in special session to hear oral argument in the case of Andrea Tuckerman, petitioner versus the Beverly Hills County School District, and Beatrice Bliss, respondents. We will be hearing from each side, first from the petitioners, and the petitioners may proceed at your convenience. If you tell me before you get started how much time you're going to be using in rebuttal.
2 minutes for rebuttal.
All right, thank you.
Thank you. May it please the court. Good afternoon, Your Honors. My name is Britt, myself and co-counsel Brady Harris represent the petitioner, Andrea Tuckerman. Today I'll first be explaining how the Beverly Hills High School violated Ms. Tuckerman's First Amendment rights, and then Ms. Harris will be addressing and explaining why an adverse inference is an appropriate sanction in cases of negligent spoliation. Today we respectfully ask that this court reverse the decision of the Court of Appeals, which improperly justified the violation of Ms. Tuckerman's free speech rights. We ask this for 3 reasons. The first is that off-campus speech is not inherently part of the educational environment, and thus a sufficient nexus between the speech and school is required in order to justify any sort of intervention. Here, this nexus is hazy at best. Second, when a student challenges the constitutionality of school's actions, the burden shifts to the school to provide some sort of justification for a legitimate reason for intervention. And third, in this case, the appropriate test would be the Tinker Substantial Material Disruption Test, and the respondents have failed to meet their burden of proof. Again, because off-campus speech is not inherently part of the educational environment, there needs to be some sort of sufficient nexus. Schools, as public agents and agents of the state, are bound by the 14th Amendment to respect the constitutional rights of all of their students. Tinker itself establishes that students do not shed their constitutional rights when they enter the schoolhouse gates, and thus it is very important for schools to respect the constitutional rights of their students.
Counsel, why shouldn't we assume that the nexus is met if there is a substantial disruption at the school?
Your Honor, any speech that occurs outside of the school could potentially impact the school, and so in order to justify some sort of a regulation by the school, there must be a sufficient nexus between that speech and the school to warrant.
Well, this isn't just any speech, though, is it, counsel? Your client accused one of the outstanding students in the high school of cheating on a test.
Your Honor,
that rises to a different level, wouldn't you agree?
Your Honor, I would not necessarily agree with that respectfully. In this particular situation, the student involved, Ms. Tuckerman, our client, did reference 2 specific students and a specific teacher in her blog post. However, in order to meet the sufficient nexus test, which is outlined with specificity in J.S. v. Bethlehem, Supreme Court of Pennsylvania case, there are 2 elements that are required in order to establish that nexus and warrant any sort of regulation by the school. The first element being that there is a targeting of a student or of a faculty member, and the second requirement being that the originator of that speech bring the speech to campus. If the originator of the speech hasn't brought that speech to campus, it wouldn't justify any sort of intervention, even if a slight disruption were to occur.
How should we interpret? Go ahead.
Counsel, on these facts, I mean, there was a student targeted. There was a student who was accused of cheating, and the audience for that blog was fellow students, was it not?
Your Honor, you're correct that some of the audience for that blog did involve students. The record states that Ms. Tuckerman was aware that there were some students who were following her blog. However, there were a majority of other people who were following her blog that were not related to the school. For instance, Ms. Tuckerman is an aspiring journalist, and she was actually hoping that blog would help to increase awareness about her writing abilities and her interest in journalism. And so there were lots of people who were following her blog that were not students.
So is your argument that if it's off-campus speech, the audience has to be exclusively people on campus in order for the Tinker standard to be applied?
Your Honor, respectfully, no, we're not arguing that it just has to be solely students. We're arguing instead that the second prong of the test, which requires the originator to bring the speech to campus, that prong must be established as well.
In the internet age, wouldn't you agree that bringing the speech to campus probably has a different spin than when Tinker was decided some 40 years ago?
Your Honor, you do have a point that when Tinker was decided, they hadn't fathomed the idea of the internet, and that does change things somewhat. However, there have been cases where the lower courts have established that internet speech, which was created by students, did not reach that level of campus by the originator of the speech.
But the question isn't whether it did not, but whether it cannot. Are you saying that we should adopt a rule that off-campus internet speech, as a matter of law, cannot be considered speech that's brought to campus?
No, Your Honor, respectfully, we're not arguing that that standard be applied at all. There are situations where the school should be able to intervene in regards to internet speech. One example would be the Second Circuit in the case of Wisniewski, where a student used an AOL profile to advocate the death of one of his teachers. He included a picture that was very graphic of a man being shot in the head with the words, "Kill Mr. Vandermolen." And that internet speech did reach the school, and the school was warranted in investigating that and taking some sort of regulatory action against that student because it potentially threatened the well-being of some of the faculty at that school.
Counsel, I'm not sure I understand the difference there between that example and this one. You said that did reach the school, which I presume means that it came to the awareness of people at the school, the message that was given, which was perhaps this teacher should be killed.
Your Honor, that particular message was accessed on campus by fellow students as well as by the student who had created that message to begin with.
Do we not think this message was ever accessed on campus?
There's the possibility that this was accessed on campus, but there is no proof in the record to indicate that it was actually accessed. When Ms. Tuckerman created the speech, she was at home using a computer that her parents had purchased for her that was her personal property. Late at night, far beyond the hours that anybody would be at school and be able to access that particular message.
Right,
There is
the message.
circumstantial evidence about the spike in cell phone use. In fact, that some of the students received automatic notifications and she posted on her blog, correct?
You're correct that there was circumstantial evidence. There was actually no proof to link the spike in cell phone violations to Ms. Tuckerman. Given the nature of the internet, for all we know, that those spikes could have been related to the latest YouTube sensation making its viral rounds.
Are you asking us to hold as a matter of law that if the internet speech did not originate on campus and was not accessed on campus, then as a matter of law it cannot be considered to have been brought to campus? Is that what you're telling us?
Your Honor, if I'm understanding correctly, your question, to answer it, we wouldn't advocate that internet speech can't ever be accessed on campus or that as a matter of law we can't intervene. It's just that in situations where there's such a slim sufficient nexus between the two, there wouldn't warrant any sort of intervention.
Well, no, my question is, let's assume that, as apparently the facts are, this posting was not made from campus. But then let's assume that no student actually accessed this blog while they were physically located on campus. If those were our facts, were you saying that as a matter of law we should hold that, therefore that speech could not be considered to have been brought to campus?
Yes, Your Honor, if I'm understanding your question correctly, if the speech was not accessed on campus, was not sufficiently brought to campus, the school would not have any sort of regulatory authority over the speech.
Irrespective of what the audience for the blog was or what the context of the posting was.
It would be irrespective of the audience of the blog in particular. Now, there's an understanding that there may be some particular kinds of content that may warrant intervention, but generally in the cases that have been established by the lower courts, all of those have involved some sort of action by the originator to bring them to campus. We discussed Wisniewski previously.
Well, Counsel, is that the case with the murder, the suggestion of murdering the teacher?
Yes, Your Honor,
Okay.
that was
I want to go back to that because I'm still not understanding why that case is different than this one. In that case, we've got internet speech that's made off campus, and it's viewed off campus, but it happens to relate to a teacher that's obviously on campus and possible actions with that teacher. Here we have a message off campus about a student alleged to have cheated on a test. The activity that's alleged is something that occurred on campus and it then caused a disruption, question whether it's substantial, but a disruption on campus with respect to discussions and investigation of whether this student cheated. I don't see the difference between those cases.
The key difference when determining whether or not there's a sufficient nexus in these two cases is the fact that in the Wisniewski case, that student did access his AOL profile using the computers on campus, and fellow students also were able to access that message via the computer on campus. This being different because Ms. Tuckerman never accessed her actual blog post on campus, and there's no actual proof in the record that the students accessed it there either. So the only way that could potentially have been brought to campus is by other students through their discussions of the blog post later. As I had previously mentioned before, the sufficient nexus here is hazy at best, but if the court were to determine that there is a sufficient nexus between the speech and between the school, then we would apply the substantial and material disruption test that was outlined in Tinker, and here the respondent simply failed to meet their burden of proving that there was some sort of substantial or material disruption to have occurred.
So you're saying that even if we conclude that there was substantial nexus, because there was not a disruption, that your client should still win, that the third prong is not met?
You're correct, that there was no substantial disruption or material disruption to warrant any sort of a regulation by the school district. The reason being is that we have two competing interests going on within the school. We have the interest of the school to be able to maintain the integrity of their environment, as well as the interest of the student in maintaining their First Amendment rights. And in this situation, we have to weigh those two competing interests, and there must be a valid and sufficient reason for the school to intervene in order to justify this kind of intervention.
How do we make a judgment about whether the 100 extra spikes on cell phone usage related to this blog post or not?
I'm sorry, if I'm understanding correctly.
You're saying the spike in cell phone traffic had nothing to do with reading this blog post.
Your Honor, there's no proof that it did have any.
And the other side is saying we should infer that it did because that's what was going on at the school at this time.
Yes, that's what the respondents would like, is the inference that that was related.
It's a fact question, isn't it?
That particular question was a fact question. At the trial court level, they determined that because there was no proof, it didn't qualify.
Who has the burden on that question?
The burden of proof to show that there was a substantial material disruption is on the respondents, and they haven't been able to provide any sort of proof that those spikes were related to the blog post.
Well, can't we consider each piece of circumstantial evidence? There's a cell phone spike. There's the fact that they were discussing it in the lunchroom. There's the instigation and the execution of this investigation. I mean, all of these pieces have to be considered to determine whether substantial disruption as a whole.
You're correct, Your Honor. They all do have to be considered. So some of the things that have been brought up before would be the position of Ms. Bliss being the Vice Principal of Discipline, that it's actually her job to conduct these kind of investigations. These investigations most likely occur on a regular basis, and the reason that it doesn't become an issue ordinarily is that it might not be related to internet speech. But that certainly is part of her job description and in no way causes a disruption per day. Another disruption that's been raised in the past is Mr. Gelding, that he had to stop his class in order to address the gossip and investigate this claim. But had this claim been made in other circumstances, he would have had to have done the same thing. That making a claim that a student has possibly cheated on a test in no way causes substantial material disruption to the ordinary course of business. In fact, those kind of claims need to be addressed by the schools, are regularly addressed by the schools, and wouldn't raise the level of being a substantial material disruption.
What's the closest case you've got factually that supports your claim that the school district hasn't met its burden to prove there's a relationship here?
One of the closest cases would be from the Third Circuit, the Layshock case. In that particular instance, there was a student who created a MySpace profile that was mocking one of his administrators. He created the page knowing that his fellow students used MySpace and that they could potentially see it, but never made any sort of contact with those students to try to push that website upon them so that they could see it. Further, he only accessed it, I believe, 1 or 2 times from school, and the court determined that that de minimis connection wasn't sufficient to create some sort of a disruption. The only reason that that particular case ever came to light was because the principal's school-age daughter found the website, brought it to his attention, and he was understandably upset that one of his students had made a mockery of him via the internet. However, the court ultimately determined that this was not a substantial or material disruption to the school, that this did not interfere with the principal's abilities to be able to maintain order within the school and to further the educational ideals of being able to prepare a citizenry for their appropriate positions in our society.
Well, it sounds like that wasn't analogous at all, because that was a situation where students happened upon the MySpace site, as opposed to this situation where the student actually had some sort of relationship with students and that they had signed up to receive automatic notification with the blog post.
Your Honor, there is the possibility, and it has been recorded, or it is in the record, that some of the students, some of Ms. Tuckerman's classmates may have accessed this blog. However, there's absolutely no indication that they had to read this post or any other post that was available. It would be as simple as hitting delete or passing along this post than actually having to read it. In Layshock, it's very similar because when this particular student did access the MySpace page, while he was on campus, he did show it to his fellow classmates, making it clear that he had passed.
Well, counsel, no one had to read the Bond Hits for Jesus poster either. That was in the Alaskan case. They didn't have to read that poster, but nevertheless, they found that the school disciplinary action in that case was appropriate. It's not a question of whether they have to read it. It's a question of whether it's targeted to an audience reasonably expected to reach school-related students, isn't it?
Well, with all due respect, the Morris case with the Bond Hits for Jesus banner, that was decided based more on the content of the banner and not so much on where he was and whether or not students.
Well, clearly he was off school, but it was a school-related function. But you were saying no one had to read these blog posts. That's not a legally relevant factor, is it? But no one has to read anything.
Your Honor, you're correct that no one has to read anything, but the idea that some of the students could be reading this, that they could be accessing it on their phones, is one of the facts that the respondents have been using in order to try to validate some sort of material substantial disruption. And so I think the two would contradict each other to say that they don't have to read it, but they are.
Well, doesn't the case law impose a reasonable foreseeability standard, not an actual proof that somebody in fact read it and was affected by it?
There are many of the lower courts, Your Honor, have addressed this idea of a foreseeable risk of reaching campus, and in many of those they've also echoed the idea of sufficient nexus. And one of the concerns with the idea of reasonably foreseeable, I see my time has expired. May I have leave to answer your question?
Yeah.
Thank you. That in a situation where it's reasonably foreseeable, any speech could potentially fall under that category. That if we're going to violate the First Amendment rights of a student, we need to make sure that there is a legitimate justification for that, and in the foreseeable risk test, that just opens up the door to far too many violations. Thank you.
Thank you, counsel. The remaining argument for the petition.
May it please the Court. Good afternoon, Your Honors. My name is Britt, and I'm here today on behalf of the petitioner, Ms. Andrea Tuckerman, to demonstrate why an adverse inference instruction can be given in the case of negligent spoliation of evidence. We respectfully request this Court to reverse the ruling of the 14th Circuit Court of Appeals and instead set forth as a matter of law that an adverse inference instruction can be given in the case of negligent spoliation for the following reasons. Negligent spoliation can justify even harsh sanctions where necessary to restore the innocent party and at the same time deter and penalize the spoliated party. Second, evidence that is destroyed, whether negligently or intentionally, can still cause substantial prejudice to the innocent party. And finally, fairness dictates that the party responsible for the loss, in this case the respondents, must bear the burden of their negligent acts. Therefore, we would ask this Court to set forth as a matter of law that a trial court does not abuse its discretion when deeming an adverse inference instruction appropriate, even in the case of negligent spoliation of evidence.
Well, counsel, I would like to speak to this particular adverse inference instruction rather than adverse inference, because there are degrees of adverse inference instructions, and it seems to me that this particular one, which essentially tells the jury, instructs the jury about the state of mind and what the import of dismissing evidence is about the harshest sanction, other than dismissing the case altogether or dismissing the claim. It's about the harshest sanction that could be imposed. Would you agree?
Your Honor, it is a harsh sanction. However, the court did tell the jury they should find. They did not instruct that they must find. They did not instruct the fact to be taken as established. So
there's a difference between telling the jury they should and they must?
There is
that difference escapes me.
Your Honor, there is a slight difference. However, I would not argue that this is a harsh sanction. However, in this case, it was justified because there was substantial prejudice to Ms. Tuckerman in this case. This was material and relevant evidence that she needed in order to prove her claim of defamation.
Well, I agree with Judge Robinson. I think that there's a strong argument that perhaps a sanction was warranted here, but it seems to me that the least burdensome sanction appropriate on the fact should be given. And on these facts, it seemed to me that the sanction that the trial judge actually imposed was far harsher than needed to be under the facts presented.
Well, Your Honor, this court has set forth that district courts have wide and broad discretion in imposing a wide variety of sanctions, and they're in the best position to make that determination of the fact and the evidentiary posture of each case. And therefore, the trial courts should be given discretion to impose the appropriate sanction that they find fits each of the different underlying policy rationales.
And so it's your position that this was an appropriate sanction for the facts that occurred?
Yes, Your Honor.
Well, and this was an unwitting destruction of evidence and kind of negligent destruction of evidence. How can we not find that this trial court abuses discretion when the next case that could be presented would be one in which the person intentionally destroyed the evidence? Yet there's really no harsher sanction available other than dismissing the case, perhaps, in that scenario. So granted, trial courts have a broad spectrum of discretion to impose, and aren't we supposed to sort of relatively measure where along the spectrum things should fall in order to review under an abuse of discretion standard the action that the trial court took?
Your Honor, respectfully, we would argue that the only way that the trial court should be found to abuse its discretion is if they found perhaps that there was absolutely no prejudice yet still imposed the sanction, or perhaps the evidence was not in fact relevant and they still imposed the sanction. But if the court has gone through and determined that there is prejudice to the innocent party, and also that the underlying policy rationales of deterrence, punishment, and remedy are preserved, and then deciding that this is an appropriate sanction, that decision must be upheld.
So you think this court only reviews the trial court's decision to impose a sanction, but does not have power to review what that sanction was? Is that what your argument is?
I think if I understand your question correctly, Your Honor, that the appellate court will review under abuse of discretion standard as to what sanction was imposed.
So I understood your argument to be that an abuse of discretion sanction, if we determine that the trial court appropriately determined, or at least under the abuse of discretion standard of review, that a sanction was imposed, that limited our review. Whereas I'm concerned whether the harsh sanction imposed for the relatively mild facts, mild for the destruction of evidence, was not itself an abuse of discretion. And that's the part of the scenario I'd like you to address more specifically. Not the fact that a sanction was imposed, but what the sanction was.
So how the courts can review which sanction was imposed?
Well, if you're agreeing, as I would think, that this court does have the authority to review under abuse of discretion standard, not only the imposition of the sanction, but the formulation of the sanction, I'd like to hear you explain why you think the sanction that this court, the specific sanction that this trial court chose to impose, was appropriate on this facts.
Well, Your Honor, that is the decision that needs to be left up to the trial court.
So you are saying we don't have a review over that?
Correct, Your Honor.
So once the trial court decides a sanction to impose, whatever sanction he imposes is non-reviewable. Is that your argument?
Well, Your Honor, I'm not sure if I'm understanding correctly. The appellate court will be able to review the sanction imposed for abuse of discretion. So yes, they could review which type of sanction was imposed as well.
So explain to this court why you think the sanction that this trial court imposed was an appropriate sanction on this fact.
Yes, Your Honor. We would argue that in the case of spoliation, it does not, the most important information is not the level of culpability of the spoliating party, but instead the level of prejudice and the damage that is suffered by the innocent party. So when the court was weighing which party that it needed to decide with and how to restore that evidentiary balance, they found that this sanction was necessary because this was the only evidence that Ms. Tuckerman had in order to prove her claim. And in this case now that it was gone, Ms. Bliss and the school district were the only ones able to give, well, Ms. Bliss specifically, was the only one able to give any relevant information as to what was in these emails. The teachers were not able to give any information. And as the lower courts have stated in the Fourth Circuit, the evidence that is lost is the most eloquent and impartial witness. There can be no substitute. This evidence that Ms. Bliss was able to put forward as far as stipulating to what was in these emails was not sufficient. All she was able to say is that these emails stated that Ms. Tuckerman was a quote-unquote well-known cheater. However, this testimony is subject to the fact that these emails were sent many months ago, and there could be lememory loss on the part of Ms. Bliss. We don't know exactly what was in those emails without having them.
Let me go back to this abuse of discretion review for a second. Here's what I'm having trouble with. I think you've agreed with Justice Melbourne that we do have a review function over which sanction is chosen. There was mentioned earlier, and there are a number of cases that suggest that ordinarily the trial court should pick the smallest sanction that will do the job, as opposed to bringing in the largest hammer at the beginning. Do you agree? There are a lot of cases that say that?
Yes, Your Honor, I agree. There are some cases.
Should we adopt that as a rule for reviewing in this case?
No, Your Honor. We would not. We respectfully disagree that a court must find a certain sanction must correlate with another, or I'm sorry, a certain level of culpability must correlate with a certain sanction. That would be to impose too strict of a standard onto the district courts.
It sounds like you're asking us to, you're saying that the trial court should almost completely ignore the level of culpability. And if one of the objectives of the rule, the civil rule procedure, as well as in the case law that's interpreted the inherent power of courts to do this, if one of the objectives is to deter such conduct, you don't solve that, you don't resolve that objective or satisfy that objective, I guess I should say, if you're only focusing on the degree of prejudice based on the importance of the evidence. But the real concern I have is that that's really, I think you're suggesting to us that's the only factor that really matters. Aren't there a lot of cases where the trial court, in fact nobody, is really in a position to weigh the weight of that evidence? I mean, to some degree there's some speculation as to how great or how awful or devastating that evidence would be. So why should we focus on that particular factor to the exclusion of the others when, as a practical matter, oftentimes no one really knows what that missing evidence would have shown?
So if I understand your question, you're saying why should we focus on the prejudice to the innocent party?
To the exclusion of the other factors. Yes.
Your Honor, I apologize if I misspoke. We would not advocate that that's the only thing that a court should take into account. However, when looking at a party that's innocent and a party that's culpable, the courts must try to restore that balance for the innocent party and not give some sort of a windfall to the culpable party just because they may have been only negligent in destroying evidence. And in this case, Ms. Bliss, this is not a case where the evidence was just, lost through no fault of anyone. There are cases that have been, such as Brewer in the Third Circuit, where the lawyer died and therefore the evidence was lost. In that case, it can't be said that there was any fault attributed to a party. But where there is some level of fault, in this case negligence, that still is a level of culpability on the part of the spoliating party, and therefore they should have to bear some of that burden of their negligence, and it's up to the trial court to determine. And what we would advocate is just that a trial court may be allowed to consider negligent conduct can impose adverse inference sanctions.
Well, the record doesn't really demonstrate that this missing evidence is really adverse to the party that destroyed it. Wouldn't the court be doing more than restoring the party's rights if they impose the harshest sanction of all, which is essentially telling the jury this evidence would have been very adverse to the party that destroyed it? That's the instructions.
The court really did even more than that, wouldn't you agree, counsel? The court didn't say this evidence would be adverse. The court all essentially took the decision from the jury and instructed them what their verdict should be with respect to this discrete issue.
Your Honor, the court did state that the jury should find that this that statement was made in bad faith. Is that what you're referring to? And this was a more harsh sanction possibly. But what other lesser sanctions could the court have imposed as far as something that courts often impose as far as
the trial court could have said that you may consider that the evidence that's absent would have been unfavorable to the school district. There are lots of intermediate sanctions that the trial court could impose other than simply essentially denying the school district its right to a trial by jury on this issue.
Or the trial court could have not instructed at all to allow the evidence to come in that these particular emails had been destroyed.
Well, Your Honor, that's a good point. I mean, the trial court could have allowed, the jury may have either way is in the position to weigh the evidence and the facts and determine whether they felt Ms. Bliss was credible, but the jury may not have known what they could do as far as taking an adverse inference without this type of an instruction. So in this case, it was necessary in order to restore that balance. And Ms. Tuckerman was very substantially prejudiced and had no other way of proving her claim through testimony or otherwise. Your Honors, one of the other underlying policy rationales that you had touched on a little earlier, Justice Robinson, was deterrence. And in the case of negligent spoliation, it can be said that a party can be and needs to be deterred from that negligent conduct. It's not only in cases of intentional or bad faith conduct where a party can be deterred. In cases such as this, Giving an adverse inference to the school district, therefore, is a very strong message sent and a deterrent sent that they must instigate litigation holds, have some sort of a retention policy, which is not shown in the record that they have anything of that sort, and also educate their staff and employees on retention of documents and make sure that their backup systems are working correctly. These are all things that would have elevated the standard of care, and we may not have this situation otherwise.
Has a majority rule emerged as to whether you can get an instruction for negligent destruction of evidence?
Your Honor, in the circuit courts that
Right.
you're referring to, there is I see my time has expired, may I leave to
You may
answer
finish
your
the
question?
question, yes.
There is at this point, small majority that would find that bad faith may be required in order to instruct on an adverse inference. However, there are a number of other circuits that have found a lower level of culpability would suffice. Specifically, the Second Circuit has laid out a very in-depth test and stated that negligence would be enough to satisfy this type of instruction.
Thank you, counsel.
Thank you, counsel.
We will hear now from the respondent.
May it please the Court. My name is Trent Byquist, and I, with co-counsel Rachel Nelson, represent the respondents, the Beverly Hills County School District, and Beatrice Bliss. Ms. Nelson will address the level of culpability required for an adverse inference instruction. I will argue that this Court should affirm the 14th Circuit's decision, holding that the appropriate standard to review school restrictions on students' online expression is the standard announced by this Court in Tinker. Tinker is the correct standard for two primary reasons. First, petitioner's online expression in this case constitutes school speech. Secondly, Tinker is particularly well suited to deal with the special problems associated with students' online speech because it provides school administrators with essential flexibility in dealing with the issue. This Court should affirm the 14th Circuit's decision that as a matter of law, under the Tinker standard, respondents have not violated petitioner's First Amendment rights.
Counsel, why shouldn't we deal with speech off campus like normal speech? The student was in her own home, was not on the campus, didn't send the thing directly to campus. The free speech rights of a student, while they are not unfettered once they go through the courthouse or the schoolhouse doors, we haven't gone near the schoolhouse, nor were we at any school event.
That's right, Your Honor. However, the facts of this case and similar facts that have arisen in the lower courts where students have expressed themselves online in a form that is available, as this Court recognized in Reno versus the ACLU, anywhere in the world that there is an internet connection, that speech must be subject to a higher standard, and the Tinker standard is the appropriate standard to review it because this speech, although not communicated at a school event or directly at the school, as this case recognized in Morse would fall under the school speech precedents, but it is the exact type of speech that Tinker was formulated to deal with. It could and did cause a substantial disruption in this case, and also...
Well, what was that substantial disruption?
The substantial disruption that actually occurred in this case was a myriad of things. The first was the spike in the cell phone.
And do we know that that spike in the cell phone usage was directly, is there any evidence in the record that that spike was directly related to this blog posting, or is that speculation you're asking this Court to engage in?
It's not directly stated in the record that that is. However, I would argue that this is below speculation because in the immediate aftermath of the online post, the very next week there was a spike in the cell phone usage. And a reasonable inference that can be drawn from those facts is that it had something to do with...
Well, that may be your reasonable inference, but why shouldn't we look at the jury's verdict in this case and decide that, in fact, that inference was rejected? The jury held as it didn't they, in essence, reject the implication that that had been a disruption? Why shouldn't we credit that rather implicit factual finding?
That's a possible finding that the jury had. However, they could have also found that the other factors that were relevant in this case and in place also didn't constitute a substantial disruption. And also there's the importance of deferring to the school administrator's decision. Ms. Bliss in this case...
In lieu of the jury?
Yes, this Court has recognized that school administrators need to have deference in how they control the school place. And although the federal courts obviously play a role in protecting students' First Amendment rights, this court has recognized repeatedly that there is an important policy rationale for deferring to school administrators' determination of how they must maintain discipline in the school environment.
But our question here is whether we're deferring to the school administrator's decision as to what the spike in the cell phone usage was. Because that's, correct me if I'm wrong, counsel, but that's what you hang your argument of substantial disruption on, is the cell phone spike usage, correct?
That's only one portion of it, Your Honor.
All right, what were the other disruptions besides the speculation on the cell phone spike?
The other actual disruptions that occurred in the school place was the investigation. And although the respondents would concede that Ms. Bliss, as a vice president of discipline, did not have her responsibilities disrupted, Mr. Gelding would participate in the investigation. Steve Saunders and Brendan Walsh, the two students who were accused of cheating in Petitioner's online blog post, were also questioned in relation to the investigation. And furthermore, the school board approved Ms. Bliss's decision to sanction this online conduct.
Seems to create a dangerous standard to me, counsel, that if the school district can decide on any allegation or any factual issue that's out there to conduct an investigation and then claim that the mere fact that they decided to conduct the investigation is a disruption of school activities, that seems to create a dangerous precedent if we were to adopt that argument.
Well, that could potentially create a dangerous precedent by itself. There's also the factor here that the lower courts have repeatedly stated that there must be deference given to an administrator's reasonable foreseeability of a substantial disruption occurring in the classroom. So although there was some disruption, and respondents would contend that that was an actual disruption and substantial disruption, there's also an element of reasonable foreseeability that this court alluded to in Tinker, and the lower courts have fleshed out more fully. So in addition to the actual disruption that occurred in the school place that Ms. Bliss noted to petitioner's parents when justifying the sanction, there was also Ms. Bliss's reasonable foreseeability of an actual disruption taking place in the classroom environment.
Counsel, I'm confused on the cell phone spike and how that fits in. And in response to Justice Melbourne's question, you said it was possible that the jury discounted that that was related to this posting.
Yes.
And what was the jury instructed?
The record doesn't disclose what they were instructed with respect to how they should interpret the spike in the school's cell phone usage.
Well, what's your basis for saying it's possible the jury made some judgment about whether that cell phone spike was related to the post?
The evidence that was put on in trial did include evidence that there was an immediate spike in cell phone usage, and Ms. Bliss relied on that spike in cell phone usage when she made her determination that a limitation was appropriate on petitioner's online conduct. So it's reasonable to conclude that the jury, being aware of that evidence, when they concluded that petitioner's First Amendment rights were violated by the respondent's actions, that is something they considered.
Was the spike in cell phone use commensurate with the lunch, all this activity in the lunchroom discussing? Is that going on at the same time?
Yes, Your Honor. Both of those events occurred in the immediate aftermath, merely days after this post about a fellow student, in fact, two fellow students, and a quiz that was administered at Beverly Hills High School. Students in the immediate aftermath thereafter began using their cell phones at an increased rate, and there was also discussion in the classroom that was, in the lunchroom that was significant enough that it immediately caught the attention of Beverly Hills faculty members who naturally were concerned as an allegation of cheating of one of their top students had occurred, and that is when they notified Ms. Bliss. So you're correct in your characterization that at the same time the cell phone spike occurred, there was also the disruption in the lunchroom, and students began to murmur and buzz about this allegation made against their fellow students.
Well, counsel, if we assume, and I'm not sure I'm willing to assume, but if we assume that the spike in the cell phone usage and the buzz in the lunchroom was all related to the plaintiff's posting, how does that constitute disruption? How is the fact that cell phone usage doubled, or whatever the fraction is, actually caused disruption in the school environment? Is there evidence in the record that because of that, classes were interrupted, or students were late to class, or did not pay attention to the teachers? How does this spike in cell phone usage actually create a disruption in the learning environment?
No, Your Honor, there's no direct evidence to the effect that there was any disruption of the learning process or students being targeted in class. There's no direct evidence of that. However, with respect to the spike in cell phones or the murmur in the lunchroom, it can be and should be reasonably inferred that this could disrupt the educational environment.
How?
No.
How did it disrupt the educational environment?
While the record doesn't disclose any direct disruption of the educational environment, it was Ms. Bliss's finding that it reasonably could have, and not only should this court defer to an administrator's, a professional educator's determination of whether it would be disrupted, but if a student is concerned or gossiping about one of the top students at Beverly Hills High School, maybe not actually being one of the top students because he's engaged in academic misconduct, or that Mr. Gelding is administering quizzes where students are capable of cheating, or students checking their BlackBerry or iPod under their desk, this can cause a substantial disruption in the classroom because students are talking about this, they're thinking about this, they're messing around on their cell phones and BlackBerries, and that can cause a substantial disruption to the educational environment.
That's not the test, is it? Whether it can? Isn't the test whether it did?
The test enunciated in Tinker spoke of a substantial disruption made.
Right.
However, in dicta, the court said that it is important that the court recognize when an administrator can reasonably foresee a substantial disruption. And this has been fleshed out in the lower courts where they've allowed the reasonable foreseeability of a substantial disruption to justify restrictions on school expression. And they have commonly deferred to the judgment of the school administrator.
What further disruption was expected here? Let's assume for the moment that we don't think the disruption you've cited so far is enough. Because with the cell phone, the jury seemed to conclude that it wasn't related. What further disruption was reasonably foreseeable such that, even though it didn't happen, we should assume it would have?
The reasonably foreseeable disruption is when one student has attacked a fellow student in an online blog post.
Right, I'm talking about our case.
That's right.
You're saying there's some further disruption that was reasonably foreseeable here, so that even if we don't think the disruption that actually occurred was substantial, you still win.
Yes.
Okay?
Yes.
So what is the further reasonably foreseeable disruption here that didn't happen that we should find was expected?
The reasonably foreseeable disruption in this case is the petitioner made a blog post accusing one of her fellow students of engaging in academic misconduct. And it's reasonably foreseeable not only that that student would take offense to that notion and accusation made against him, but he might do something or take some action against the petitioner as a way of retaliating or as a way of defending himself.
That's pretty far-fetched, isn't it, Counsel?
Particularly in a high school environment, wouldn't just about everything be disrupted?
Particularly with an outstanding student such as the one involved here, to think that the reasonably foreseeable substantial disruption was that he might go Columbine on the student who made this posting. Isn't that pretty far-fetched?
I agree. Stating that the student would be a threat to do something similar to what occurred at Columbine High would absolutely be a stretch. However, Your Honor, I don't believe it's a stretch to say that this student might take some action in order to defend himself against this attack against his academic character.
You're talking about physical action?
I think that that would be unlikely because, as you stated, this
You're
is
talking about further speech.
Potentially further
Which
speech.
brings us back to a circular argument as to whether or not the court should suppress that type of speech.
Correct, Your Honor. However, I don't think the argument is circular in the sense as there's more and more speech, the chances of it becoming disruptive and getting in the way of the educational mission of the school.
So we like free speech as long as it's just a little bit of it. But if there's too much of it, then we don't.
No, Your Honor. However, it is reasonable for a school to step in and say, at a certain point, enough is enough. If this were to go further, and admittedly it does in fact don't disclose, but if this were to go further and it was consuming the faculty members' discussion, it was consuming the discussion that the students were having at all times, faculty members were having to take time out of their classroom to address this issue with the students, that is a reasonably foreseeable disruption.
But this is a question of what's a reasonably foreseeable substantial disruption to this school from one student posting online away from the school that she thinks another student cheated one time. And we're supposed to assume, let's take the cell phones out again because the jury seemed to not buy that. We're going to assume that there would have been some substantial disruption that didn't occur from this single allegation against one student.
Yes, Your Honor. And that is a safe inference for this court to make because of the policy that the courts have in deferring to school administrators' professional judgment in the educational environment.
But we also have a policy of deferring to juries in their judgment. And the jury here found a violation of First Amendment rights of the student by the school, which seems to suggest the jury was not impressed with the disruption of the school environment.
That's right, Your Honor, and there is obviously a policy of deferring to a jury's factual findings. However, many of the lower court decisions that have decided this issue, and what we're asking for relief here is for this court to decide as a matter of law that the respondents have not violated petitioner's First Amendment rights because there was a reasonably foreseeable disruption and this speech collided with the rights of the other students. So although there is some deference made to the factual findings in this case, respondents are asking this court to find that there simply wasn't enough shown by petitioner to substantiate that her First Amendment rights were violated.
Let me be sure I understand your argument. Your argument is that we should overturn the jury verdict not because there actually was a substantial disruption, but because it was reasonable for the school administrators to fear that there would be a substantial disruption. Is that your argument?
Although the respondents would contend that the actual disruption was enough, the reasonably foreseeable disruption would be grounds to overturn the jury's verdict in this case. And furthermore, Your Honor, the collision with the rights of other, which is the second column of the Tinker standard, that speech may be regulated when it collides with the rights of other students, would also justify overturning the jury's verdict, because Steve Saunders and Brendan Walsh, the two students who were accused of cheating in the petitioner's online blog post, have the right to not be accused of engaging in academic misconduct.
How do we know they didn't do it?
The investigation that was conducted by Ms. Bliss determined that the allegation made was entirely baseless and also made with...
That was the school, that's your client. So your client says it was baseless. And we should accept your client's view that it was baseless to let your client out of the lawsuit.
Yes, Your Honor, and I'll explain
That
why.
seems like a really circular argument.
The reason that her determination should be given credit by this court is that the investigation was conducted long before this litigation was instigated. Ms. Bliss was simply carrying out her duties as the school's vice principal, and she...
Wasn't it at the same time that she said that the plaintiff had cheated on exams, something he had no support for?
The investigation was conducted prior to that time that she said that. However, it was in much closer proximity than when this lawsuit was actually initiated.
Right, so I'm wondering why that suggests we should accept her fact findings. We know she was wrong on the other one. There's no evidence to support the idea that the plaintiff ever cheated on an exam. Is there any evidence in the record to support the idea that the plaintiff ever cheated on an exam?
I see my time has expired. May I please answer your question?
Along with the follow-up question, which is, if there's no support for that, why should we believe Ms. Bliss's conclusion on the other investigation?
Okay. With respect to the first question, Your Honor, there is no evidence in the record that plaintiff ever cheated on an exam. With respect to the second question, the reason that this court should accept Ms. Bliss's finding is that this was in her professional capacity, and this is what she was responsible for, was investigating these kinds of allegations of academic misconduct. And there's no evidence in the record that she engaged in any sort of manipulation of the evidence. She spoke to the petitioner, she spoke to the two students who were implicated in the petitioner's accusation, and she spoke to Mr. Gelding, who administered the quiz. And for those reasons, there's no indication that her findings in this investigation should be discounted by the court.
Thank you, counsel.
Thank you, counsel.
Final argument for the response.
May it please the court. Good afternoon, Your Honors. My name is Rachel Nelson, and I represent the respondents in this case, Beverly Hills County School District and Beatrice Bliss. This court should affirm the decision of the 14th Circuit Court of Appeals, which held that a court may not issue an adverse inference instruction for the spoliation of evidence where the parties' acts constituted mere negligent behavior and there was no evidence of bad faith.
I'm sorry to interrupt you so early, but your position is not just that they should not have issued this particular sanction, but that the district court should not have issued any sanction at all.
No, Your Honor, my position is that in this case, an adverse inference instruction was an inappropriate sanction for negligent conduct.
Any adverse?
That's what I'm saying. You're saying that the trial court should not have made any sanction at all for the destruction of evidence. We engaged in quite a bit of discussion with the petitioner about the level of the sanction, but you're asking us to find that any sanction, however mild, would have been inappropriate.
No, Your Honor.
On these facts.
No, Your Honor. Other less severe sanctions would be appropriate on the facts of this case. However, a severe adverse inference instruction that instructs the jury that it should infer an essential element of the petitioner's claim is an inappropriate sanction. However, there are less severe sanctions that would be appropriate in this case. This court has unlimited power to establish standards of law. Therefore, its review of this issue should be de novo, although generally court-imposed sanctions are reviewed under an abuse of discretion standard because we are asking that this court establish a new standard of law, that negligent conduct alone is insufficient to impose an adverse inference instruction that severely prejudices the opposing party is an inappropriate response.
Counsel, wouldn't it be a better rule if we said once it's obvious that a lawsuit is imminent, that negligent destruction of documents would justify an adverse inference? Because we have so much electronic evidence these days that if people don't preserve it once it's obvious a lawsuit is imminent, key evidence is lost and the other party is innocent in this case. In this case, we've got key evidence that's lost. There's nothing the other party could have done to preserve it because it was within your client's control.
Yes, Your Honor, you're correct. The other party had nothing to do with the spoliation of evidence. However, the trial court found that this was negligent spoliation of the emails. And the school did take steps in order to ensure that this evidence was not damaged or lost or destroyed. And in this case, Ms. Bliss deleted the emails with the mistaken belief that they would be saved. She knew that she was...
What I'm saying is, in the best of all worlds, we decide cases with the evidence that actually should be there, not evidence being missing. And going forward as a policy matter, it would seem like the strongest message we would send would be, if you know a lawsuit is imminent, even negligent destruction of evidence is going to result in an adverse inference, so you better be really careful, as other counsel said, put a litigation hold out, be sure all the evidence is maintained.
Yes, Your Honor, that is a possibility. However, to tell parties that they need to know what would be relevant to a pending lawsuit is something that you can't expect normal citizens to have the knowledge of what to preserve. These people are not lawyers who know what would be relevant to a defamation claim. Ms. Bliss knew that the lawsuit was pending because she had been notified of that fact by petitioner's parents and the lawsuit had been filed. She deleted these emails knowing that they concerned petitioner's claim with the mistaken belief that they would be saved regardless of the fact that she deleted them because the school had a backup system. However, that backup system failed in this case. And this type of conduct is not something that can be deterred by telling parties that they need to preserve, especially electronic information, which is often destroyed routinely based on a good faith operation of a system. And
but those aren't our facts. This was not routine destruction based on the regular operation of the system. This was deliberate, selective destruction, obviously not of targeted emails, but of the whole class of emails. Correct?
Yes, Your Honor.
And are you saying that there's no way that a non-legally trained individual such as your client could have known that these emails would be relevant to the claims?
No, she knew that the emails were relevant to the claims. She knew that they discussed...
So you're saying that we should say that they're free to destroy relevant evidence as long as they have a hunch that there's an equivalent cache of similarly relevant evidence somewhere else. Is that the rule you're asking us to now?
No, Your Honor. Parties are not free to destroy relevant evidence. In this case, Ms. Bliss did destroy the emails, believing that they were going to be saved by the backup system. And the court found that this was negligent conduct. It was not something that she intended to do intentionally to destroy petitioner's defamation claim. She also destroyed other emails in her box just to save space in her email account, which was a matter of routine for her.
Do you concede that it was negligent conduct, or are you saying that it was absolutely blameless?
No, it was negligent conduct.
All right.
Yes, the court found that it was negligent conduct, and she did take the intentional act of deleting those emails. It was not something that the system did on its own. And this is something that cannot be deterred as easily as negligent acts, generally speaking, where people are under a duty to act reasonably in their acts. In this case, there are three purposes, and those purposes are not furthered by imposing an adverse inference instruction for spoiling negligent or spoiling relevant information.
Well, under these facts, what would restore the party to the position they would be in if they have that evidence? It seems to me that at the very least, that's what the sanctions should perform.
Yes, Your Honor. Under Rule 37, district courts have the power to impose less severe sanctions that would restore parties to where they would be, or make an attempt to restore them and keep them on an equal playing field, rather than this harsh sanction, which basically gave petitioner a windfall verdict because it instructed the jury to infer that essential element, the only element that she could not prove, based on these emails. Under Rule 37, the court could prohibit the spoliating party from introducing certain matters into evidence It could prohibit them from supporting or opposing specific claims or defenses. It can inform the jury that they failed to produce the evidence and let the jury make its own determination on whether or not that party was acting with a sufficient level of culpability because they know that the emails were not given. And it also could shift the burden of proof to the spoliating party to disprove the element by saying that these emails were not produced. The Sixth Circuit has created this rebuttable presumption, something similar to what I'm describing, in Welsh v. United States, and shifted the burden of proof to the spoliating party, in this case, to allow Bliss to establish that her statements were not made in bad faith. She could introduce evidence, bring on other witnesses, and this would just be something that would create a balanced approach for parties.
Is there one of those that you agree should have been done in this case?
Yes, Your Honor, something similar to this could have been done in this case.
Well, you're saying the court should have given some sort of adverse inference instruction?
Not an adverse inference instruction. No.
Okay.
Not one at all?
No, Your Honor. An adverse inference instruction for negligent conduct, like it was in this case, is not something that would be appropriate. However, informing the jury a less severe sanction that the evidence has been lost or that the party failed to produce it.
Well, you said they could flip the burden of proof.
Yes.
Essentially, that's making an adverse inference, isn't it? It's saying we're going to assume that these emails didn't give any information to Ms. Bliss that the plaintiff achieved.
Yes, Your Honor. It essentially has the same effect as an adverse inference instruction. However, it's not as explicit as saying to the jury that they should infer that her statements were made in bad faith. That's something that is basically an irrebuttable presumption for the respondent.
Well, what if we said they may infer?
Even that, in this case, is inappropriate because it's still an inference instruction to the jury based on the level of culpability that she had. You're saying that she did something in bad faith based on zero evidence of that she did do something in bad faith. These emails were destroyed, and she deleted a block of emails. These emails could have been something that was helpful to petitioner's claim, which presumably they were relevant to her claim. They dealt with the discipline that Ms. Bliss imposed on the petitioner. They could have been helpful to, and they could have provided exculpatory evidence for respondents.
Are you saying that in the absence of a finding of bad faith, no adverse inference instruction of any caliber is warranted? Is that what your position is?
No, Your Honor. My position is that anything above negligent conduct, it doesn't have to reach the level of bad faith. But intentional acts, it has to be something that is intentional to disadvantage the other party in the litigation.
So there has to be intentionality before any form of an adverse inference instruction can be given.
Yes, Your Honor, that is our position.
Let me take you back to the beginning, because something you said earlier confused me. What standard of review do you think we're examining the trial court's decision on?
We would ask that this court use a de novo review over this issue and establish a new standard of law, which would essentially lead to the district court acting at abusing its discretion and imposing this severe of a sanction for.
So you disagree this is an abuse of discretion. You disagree that we owe any deference at all to the trial court's determination as to what should happen in trial, and you're saying that we should rewrite the law entirely and apply that retroactively.
Yes, Your Honor, that is what we're asking in this case, because negligent behavior is simply something that is not deserving of such a severe sanction. There are three purposes behind an adverse inference instruction, and none of them are furthered by imposing the instruction based solely on negligent conduct when there's no evidence that there was intentional, willful, bad faith conduct that attempted to spoil the other party's evidence in an attempt to win the case.
Is one of the purposes deterrence?
Yes, Your Honor.
Doesn't it deter negligent conduct?
Yes, negligent.
If we do it properly, it's going to preserve more evidence.
Yes, Your Honor.
Therefore, deter destruction of it.
Yes. Giving an instruction like they did in this case could potentially deter people from destroying relevant evidence, but people do not know what they need to be preserving when it comes to evidentiary disputes. When you're talking about sanctions for discovery and failure to produce things in discovery, people are not aware of what they need to be saving. It's not, you can't expect people.
Counsel, you're asking us to believe that she had no idea that this information could have been relevant and should be saved?
No, Your Honor, she did have an idea that this information was relevant, but she relied on the backup system and when she deleted the emails. And this is something that can't be deterred because the school had a backup system in place. The school informed Ms. Bliss of the litigation.
Oh, it could be deterred if we adopted a rule that the destruction of any relevant evidence, whether or not that evidence was duplicated somewhere else, was sanctionable. That would deter it.
That could deter it, but to believe that people are going to know what types of things are relevant to litigation.
But you already told me that she knew that this was relevant, so that's not pertinent to this case.
It's not pertinent on these facts, but generally speaking, if you're
Well, let's just talk about this case. She knew this was relevant. Wouldn't a rule that says even the negligent destruction of known relevant evidence is conduct that should be deterred? Why isn't that a rule that we should champion?
Well, Your Honor, in this case, Ms. Bliss, she believed that these emails were going to be saved. She relied on this backup system. This is doing more than we would expect normal people to do in preserving relevant evidence. She believed that they were going to be saved. She deleted a chunk of emails to create space, and that's something that's just simple negligent conduct. It wasn't made in bad faith. The court found that she did not do these acts in bad faith. It was not intentionally.
Well, the law punishes negligent conduct all the time.
Yes.
And auto accidents and medical malpractice and all sorts of things. The whole gamut of torts, the law punishes negligent conduct. But you're saying here negligent conduct should not be sanctioned.
It's not as easy to expect people to know what their duty is. Under normal negligence law, people have a duty to act reasonably to avoid harm to other people. Here, it's an evidentiary dispute. It's something that's not as simple to know. I need to be saving all of my emails, especially for companies and businesses that have tons of electronic stored documents and emails that are routinely deleted, things like that. The court has enacted in 37E has attempted to address these types of issues in creating a safe harbor provision for parties that destroy relevant electronic stored information as a result of a routine good faith operation. I'm not saying that this applies to the facts of this case. 37E does not apply. However, this rule shows that the Rule Committee has made a clear policy statement that these types of acts need to be protected. Negligent conduct, where something is deleted because of no fault of their own. And that further supports the inference that negligent conduct cannot be deterred in these circumstances for electronic spoliation of evidence. Additionally, this sanction is an extremely harsh sanction and severely prejudices the spoliating party when their conduct constituted mere negligent conduct.
Counsel, I guess I don't understand why you think it's appropriate for us to adopt a whole new standard and do a de novo review. When right now the trial courts really have a lot of tools in their quiver. They, an abuse of discretion standard, they can consider all of the factors. They can consider, as the petitioners want, what they think the weight of that evidence would have been. But they can also consider, the relative culpability of the person who destroyed the evidence. They can consider, under those circumstances, what would deter future conduct just like this. Why should we not just keep the standard that we have now?
Your Honor, I see I have expired my time. Can I please have wait to briefly answer your question?
Okay.
Under these circumstances, it's not as easy to say that. I'm sorry, can you repeat your question for me?
Well, I'm asking why are you advocating for a de novo review, and why shouldn't we just do the same old abuse of discretion review? Because the abuse of discretion review recognizes that the trial court has discretion to consider all of these various objectives of the spoliation rule, and considers the specific facts in that case, such as the weight of that particular evidence that disappeared or was destroyed, etc.
Yes, Your Honor. However, that is a jury function. The jury should be able to consider the evidence rather than the court instructing it based on evidence that does not exist. And this type of a sanction essentially instructs the jury on this essential element of her claim and gives her a windfall. It's extremely inappropriate to impose this severe of a sanction on a party when their acts constituted negligent conduct. Thank you, Your Honor.
Thank you. We have time for 2 minutes for rebuttal now.
Your Honor, with all due respect to the Respondent's Counsel, there are a few misapplications of the Tinker Standard that have drawn some great concern as far as petitioners are concerned. The Respondent has advocated that the Tinker Standard is the appropriate standard to apply. However, these misapplications create some serious issues in whether or not this case actually would satisfy the Tinker Standard. First of all, to prove substantial and material disruption, the Respondent has really only asserted that mere gossip within the lunchroom would qualify as a substantial and material disruption. However, to advocate a standard and to apply a standard that would suggest that gossip alone is a significant enough disruption within the school would essentially chill all of communication that takes place within a high school setting. That also, it neglects the idea that Tinker specifically asserted, which is that any spoken word whatsoever has the potential to cause some sort of a disagreement between parties because of not always seeing eye to eye. And it's a risk that we have to take when trying to protect the First Amendment rights of all citizens, including students. Second, the respondent seems to suggest that a forecast of a disruption would be enough even if no disruption had already occurred. But it is the respondent's burden to prove that some sort of a disruption could be forecasted, and they offer absolutely no proof to suggest that there is anything in the record that would indicate some sort of disruption occurring in the future. Further, the only evidence that they seem to suggest is that Ms. Bliss simply didn't like what she had to hear about one of Beverly Hills High School's quote-unquote brightest stars. Tinker specifically states that just simply disliking what a person has to say is not adequate justification for regulating their speech and for violating their First Amendment rights. Because of these reasons, the respondent has still failed to meet their burden to prove that any disruption occurred or that any disruption could potentially be forecasted.
Your counsel, isn't all of this a little bit tainted by the fact that the jury was instructed to accept a key fact for your side?
I'm sorry, Your Honor.
On the defamation claim, the adverse inference instruction, that was so strong, I'm not sure we can rely upon the jury's instructions and the jury's finding to conclude there wasn't a substantial disruption from the cell phone records and all the other things that were presented.
Your Honor, my time has expired.
You may respond to the question.
Would you mind repeating the question, please?
Sure, my question is just, we have this adverse inference instruction, it may not have been proper. And with that instruction, the jury found in your favor. But should we really conclude the jury found in your favor since they got an instruction we may not be able to uphold?
Your Honor, if I'm understanding everything correctly, I may not have been completely clear about what specifically we're discussing as far as the Tinker standard applies. In regards to the Tinker standard, the jury or the adverse inference did not actually impact that particular issue. The adverse inference that was instructed was specifically in regards to the defamation claim of the comments that Ms. Bliss had made and not actually related to the comments that Ms. Tuckerman had made regarding her free speech issues. So for those reasons, I would suggest that those two don't actually correlate and that here we still have not met the burden of proof.
Thank you. We appreciate the argument from both sides. It's been an excellent argument. The court will take a brief recess.
All rise. This honorable court is now in recess.